I've taken more of an external perspective, teaching about the design of the Supreme Court and the Constitution as contingent choices. I sat on the Supreme Court Commission and added to my Civ Pro course a unit on court reform to engage the question and meaning of independence, legitimacy, but also in relation to these design questions and choices that are constitutional and policy choices about how long terms should be and the size of the court. And I know that many of my colleagues in con law and Fed courts did this as well. Those in con law, and this relates to the Constitutional Democracy Initiative, that we have at Columbia, really added a lot of materials about constitutional amendment, both as a process, but also comparative materials to really think about the choices that are embedded in the US Constitution. And then I can say more about the Constitutional Democracy Initiative as we go on, but the larger theme is that it's not really about this Roberts Court, or not just about the Roberts Court. It's about a broader conversation about American democracy right now, of which the Constitution is a part. And all of that has seeped into our teaching. We have from the start, when students arrive, small discussion groups where they can engage the kinds of questions they were probably thinking about before law school in small group seminars with our faculty. So some of those are about public law issues, some are what you might call private law issues. So I don't separate what's happening with the Roberts Court from other kinds of phenomenon around polarization and racial conflict.
Great, thank you. So, all right, I'll go back to Professor Goodwin. So let me just, do you want me to repeat the question, or do you think
No, I have a question, and thank you so much. I think this is such an important gathering as we think about teaching the Roberts Court, the challenges and opportunities. And first, I think what's important by this gathering is to think about the teaching as being important and understanding the challenges and the opportunities that express value and nuance and engagement, and that foundationally, this is about a respect for rigorous debate and an openness of expression. So I want to thank you for actually hosting this. And it's within that spirit that I want to think about what the Roberts Court represents and its role in shaping legal norms, as well as the challenges that lie ahead for teaching our students. And so for me, as I've thought about the arc of reproductive rights and freedom before the court, it's interesting to think about the Roberts Court. In the last year, there has been a firmer turn towards originalism, and that raises questions about history. There is the debate as to whether there's any value in originalism at all. And what's interesting about that is that for the most part, most have said there's no value there. But of course, that shuts down discourse altogether. And what it may tend to do is to overshadow the actual value of looking at history and the role of history in thinking through matters of reproductive rights and freedom. So on one end, while there has been a critique of originalism as closing the door to understanding women in conversation with the United States Constitution, and the expression that there was no real value or women written into the Constitution at its ratification in 1791. On the other hand, what looking at these reproductive rights cases have meant under the Roberts arc, and it's important to understand that that's more than Dobbs, but that's Gonzalez v. Carhart, that's Whole Woman's Health v. Hellerstedt, that's June Medical v. Rousseau, et cetera, is to think about what these matters mean in the context of a different time of ratification, and that's the Reconstruction Amendments. And what do those Reconstruction Amendments help us to understand? Well, there's a lot that's been lost, actually, in historical understanding and meaning there. For example, there is a way in which it seems that sex and race, that intersection, ends up being bled out of how we understand Reconstruction, such that for students, it becomes an eye-opening discussion to understand the texts, the debates that were occurring amongst the abolitionists in Congress. The abolitionists in Congress who were paying close attention to the advertisements at the time that were seeking the recapture of women who had escaped, girls who had escaped with their children, right? Part of what was open and the sources available, but also who these abolitionists in Congress were, who were shaping the 13th and 14th Amendments, and people like Charles Sumner and others, and to understand the arguments that were being made and how, interestingly enough, even though we don't talk about it very much at all, but so central to the debates that were being articulated, the speeches written, etc., was about the sexual subordination and involuntary reproductive servitude of Black girls and Black women. And these are documents that are very easy to find, but have been overlooked both by those who take a progressive view of the Constitution and also those who've articulated a conservative view of the Constitution. And what's been left behind is the rendering of invisibility of those who were central to the articulations that lead us to the 13th Amendment and 14th Amendment. And I'll end it there, but I really appreciate so much that we're having this conversation. The last point that I will make is that in thinking about teaching the Roberts Court, is there's also been the invisibility of the attacks that have come against the Chief Justice within this space, as more recent cases he has signed on with liberals, including in June Medical v. Rousseau, the concurrence that he ends up writing in the Dobbs decision, and there's more that we could talk about there too.
Thank you. Okay, so Professor Lemos, you have co-authored a recent casebook about judicial politics. And as it turns out, you actually teach a course on teaching about the Supreme Court. So I wondered if you could tell us about that casebook, the course, and what we can learn when we teach about the court.
Yeah, I'd be happy to. And thanks so much for me as well. This is a great conversation to be having. I'm sure we're all having many versions of this conversation in our own institutions. And it's terrific to be able to kind of expand the view out a little bit. So the book and the course are both efforts to study and get our students to study courts as institutions in the same way that we might study Congress as an institution. So, you know, for students in the audience, I think those of you who have taken leg reg or legislation or administrative law probably learned some stuff about how Congress works and who's in it and what their motivations are and how agencies work and so on. But although, you know, we in law schools are critiqued sometimes for focusing too much on courts, we actually do very little in the mainstream curriculum to teach about courts from an institutional perspective. So that was kind of the inspiration for the book, which I should say we started a decade ago, so well before current developments on the Roberts Court. The we here is a collaboration between a bunch of law professors and a bunch of political scientists. And our goal is to kind of bring together the teaching from these two fields. And so the book and the course focus on various factors other than law or legal doctrine that can influence how judges decide cases and ultimately how the law develops. So there's a chapter on ideology, of course, but also on patterns of litigation and advocacy, on the judicial hierarchy, on the pros and cons of having judges decide cases together in a multi-member court, on the relationship between court decisions and public opinion, and between courts and the political branches, on the effects of different methods for selecting and retaining judges, and so on. And I think one of the things we think is important is to try to convey to students the importance of seeing the US Supreme Court and all courts as part of a larger legal and political ecosystem and not just in isolation. So the overwhelming majority of social science research on courts and judicial behavior does focus on the US Supreme Court. But the goal of the book and the court is to teach about all US courts, both state and federal, and to situate those courts in relation to each other and also in relation to the rest of government. And we think that even if at the end of the day, your interest is ultimately in the Supreme Court, it's impossible to understand that court fully without seeing sort of the broader picture. So on the one hand, seeing that what happens at the Supreme Court is in response to various moves that other players in the system have made, political actors, social movements, advocates, so lawyers. Lawyers have a pretty central role in the story we want to tell, other courts, lower state and federal courts. And then on the other hand, how the Supreme Court's decisions get their meaning and their full effect only due to the reactions of other players in the system. And so for me as a law professor, as opposed to a political scientist, it has been particularly interesting and also challenging to be pushed to think carefully about what the social science research about courts can tell us and what it can't. And that's a variation, I think, on the struggle many of us are having right now in trying to figure out sort of what role to give to doctrine and what role to give to the not law stuff, the other than doctrine stuff. And I will say that that is much easier when it's your actual subject than when you're teaching a class that's supposed to be about doctrine, and then all this other stuff is in the background. And so I am teaching this class this semester, and it's been hugely refreshing, and I think rewarding for me, I hope also for the students, to be able to actually dig in and think about what we know and what we want to know about the courts as institutions. And I think importantly, to be able to push past some kind of simplistic and caricatured understandings of judging and of law. My students, I'm guessing your students are the same, do not need much help in rejecting a kind of formalistic or mechanical understanding of the law. You know, it shoots out right answers and the judges are just calling balls and strikes. But many of them, I think, jump too far from that to the other end of the spectrum and to what is an equally simplistic and caricatured view in which the law is nothing but a post hoc rationalization for a decision that was reached entirely on other grounds. Even if or even when that view is correct, it still leaves open, I think, a bunch of important questions, like, you know, do we think all judges are behaving like this or only some, and why? Do we think this is happening in every case or just some, and why? So on and so forth. So our students are going to go on to be advocates in this system. Many of them will be litigators in this system. Some of them may be critics. Some of them may want to be reformers. Some of them may be defenders. And in any of those roles, I think there's a ton to learn about how the system is set up and why it's set up that way and how it actually works, that we in law schools can do, I think should do, a lot more to teach more explicitly than we currently do.
Great, thank you. So, Professor Barnett, having heard some of our fellow panelists on these topics, do you think there is anything different about the Roberts Court that might require that we change or alter anything that we do in the classroom?
Thanks for having me. And the answer is yes, I do think there is something that needs to be changed. But before I get to that, I want to stress the agreement I have with the previous speakers, especially the last two. Both Michelle and her emphasis on the 14th Amendment and Reconstruction, and Maggie on her emphasis in putting Supreme Court doctrine while teaching doctrine into a larger context to understand the doctrine as the most effective way of teaching doctrine, actually. I have a case book myself. It's actually been in print for quite some time. And my approach has always been, first of all, I'm an outsider in the sense that I have always put myself in strong disagreement with things the Supreme Court has done throughout my life. So I'm teaching an institution that I'm not completely in agreement with. I'm not completely of that institution. And so I'm sort of teaching it as a third party looking at this institution. And the best way I have found to teach it is to teach constitutional law, the development of constitutional law, not as a series of set doctrines, but as a constitutional narrative that begins at the founding and works its way to the present. So my casebook, for example, obviously emphasizes the founding. It then goes through the Tawny Court and has several chapters, at least 2 chapters on slavery and the role that the relationship between slavery and the original Constitution, moving into the Civil War, then Reconstruction, then the Progressive Era, then the New Deal era, followed by the Warren Court, the Rehnquist Court, and now the Roberts Court. In my experience, and also my casebook offers to those who use it, 75 videos that students watch before they come to class, which uses the flipped classroom model so that students are prepared to discuss the materials better than they usually are. And you can move on to other topics and don't have to just cover the basics, because the basics they get from the videos, if nowhere else. What this allows me to do is situate any court, it used to be the Rehnquist Court, now it's the Roberts Court, in a narrative that shows there is a left side and a right side, and there's always been multiple sides of the court. And each of the justices sort of views themselves as characters in a play that has been running for a very long time. And they view themselves as characters are either on one side of this drama or on the other side of this drama. And they try to maintain some internal consistency with what they view as their historical role in this drama. So that, I believe, when you do that, it's no longer superfluous to bring into the class the issues of slavery, the issues of racial subordination after the Civil War, which goes on for another 100 years. Of course, we also read about the massive resistance to the Warren Court in our casebook. Once you've teach doctrine and how it's developed that way, it's not like the students don't believe you're adding something extra just because you care about it. They believe that you're teaching them something essential for them to know as a constitutional litigator, which I have been. I'm the lawyer that brought the lawsuit in Gonzalez versus Raich, the medical marijuana case. I argued that case in the Supreme Court. I'm teaching them, and I can tell them I'm teaching them what I need to know if I'm ever litigating a constitutional case, to understand where these justices are coming from. So that's where I have, I believe, common ground. I don't teach the social science of the courts like Maggie does. I teach more the history of how the Supreme Court has developed its doctrine over time. But now here is what I think, and first of all, I think most law professors don't necessarily teach that way, and they should probably do so, but I'm partial. The other thing that I think is important for law professors to change, and it was raised by your earlier question, and that is that we do have 5 justices now for the first time in our lifetimes who identify as originalists. And I do think that puts a burden on law professors to teach what originalism is in a sensitive and sophisticated manner. And I have to tell you, most law professors don't do that, partly because they don't have a sophisticated or nuanced or up-to-date understanding of what originalism themselves. Sometimes they do, but they prefer to bash it rather than teach it sympathetically in any way, shape, or form. And I think this does our students a disservice. We have 5 justices who identify as originalists. It's important to tell the students and teach the students what that is. Now, if you do that, one of the things that you will realize is that we don't actually have an originalist court, because even though we have 5 justices who profess to be originalists, and our most recent justice, Ketanji Brown Jackson, who has identified originalist methodology as her methodology during her confirmation hearings, although she didn't use the label, we don't actually have 5 justices who are committed to following the original meaning of the text over and above other considerations that they may wish to follow instead. We do have, without doubt, a conservative Supreme Court. We have a 6-justice conservative majority, but we do not have a 5-justice originalist majority. And if you have a sophisticated understanding of originalism, or I just think a nuanced understanding of originalism, you will realize that, for example, in the last term, that the Bruen case was Justice Thomas's opinion in the Bruen case, the gun rights case, the concealed carry case. That was an originalist opinion, and you can teach. It may not have been a correct opinion, or it may or may not, but it was an originalist opinion. But then if you teach the Dobbs case, then you'll have to say that that was not an originalist opinion. Justice Thomas's concurring opinion was originalist, but the majority opinion was adopted modern substantive due process, interpreting the due process clause the way a conservative would like to interpret the due process clause, and made no attempt to be originalist. in any meaningful way. And in the article that I have forthcoming in the Northwestern Law Review, Professor Solem and I explain both those cases, as well as the Coach Kennedy case, and try to understand what is the role of history and tradition in originalism, and how has the court been using it to facilitate originalism, and how have they not? So I guess I'm going to stop by simply reemphasizing the fact that if law professors do not themselves understand originalism well enough to inform their students as to what it is, it makes them unable to effectively both teach what the justices think about themselves, as well as teach where the justices fall short. Because originalism is, in very important measures, a critique. It's a critical approach to constitutional law. It has been accused of being a reformist approach to constitutional law. I think that's probably accurate. And the only way to critique the court on its own terms is to understand what that term originalism means and what it does not.
Thank you. So, Professor Chang, you have focused on state courts and state constitutionalism. Does law school teaching place too much emphasis on the Supreme Court and our federal courts at the expense of state courts? And what do you think we could learn by shifting our emphasis to state courts?
Thank you for the question, and also for including me in this conversation. My short answer is yes. We pay too much attention, I think, to the federal system. And I think we do a disservice to our students by not teaching them about state constitutional litigation and the importance of it. Now, when Professor Charles invited me to participate on this panel, I said, do you have the right Robert Chang? It's like, because, I haven't yet had the privilege of teaching con law or having a con law casebook or anything like that. And my facetious response in some ways to teaching the Roberts Court was, well, don't. And it is facetious. I do federal constitutional litigation, so I have not given up on the federal courts, not in any manner. But I do think it's, rather than one or the other, we really need to do more with regard to the state constitution, state constitutional litigation, which I don't think we do. And so for some years now, in the Korematsu Center, we've had sort of in our quiet phase, what I call the subnational constitutional law project. Subnational is just a different word for state constitutional law. And what we've been trying to do is work specifically within Washington state, though also sometimes strategically in some cases that we get invited into in other states, to really think about, well, what might state constitutions do? What might the Washington State Constitution provide or afford in a way to get around some of the challenges that exist with regard to dealing with racism in the US constitutional system? And so in some ways, like for years, well, going back to Washington versus Davis, it's like, the limits of federal anti-discrimination law, the requirement of intent. So what we know often at the end of the day is we have racially disparate outcomes. We have racially disparate outcomes, and there are many who acknowledge that there is racism in the system. But what we have, because of the limits of federal anti-discrimination law, if a person can't prove that they received the death penalty because some particular identified perpetrator acted with animus in a way that caused harm to this particular person, there's no relief. And so that's McCleskey versus Kemp. And so when we think about it, well, is that the only pathway? Are there other things that we might think about or do? And so then with regard to Washington State, what we did is we thought about the opinion in McCleskey that talked about, in some ways, well, the fact that some people who commit heinous crimes, very severe crimes, don't get the death penalty, well, that doesn't mean that the defendant in that case gets that kind of relief. And so, but if we think about it, well, what is it that makes something cruel? What makes something cruel is if it is applied in an arbitrary manner. And so if there's racism in the system, that's arbitrary. And so it's a way to get at outcomes. And so one of the things that we brought to the Washington State Supreme Court is the operation of in-group favoritism. And so when we think about racially disparate outcomes, it's not just that a Black defendant might be the victim of discrimination based on race, it's also that white criminal defendants might receive mercy through the operation of in-group favoritism. And so we have an account for outcomes, and it then affords a way for the court to say, well, that's arbitrary. Arbitrary based on race is cruel. If it's cruel, then it's impermissible, even though we can't say that this particular defendant suffered from racism because of the death penalty that they got. We've also been doing a lot with regard to fairness in the criminal legal process, and it's also gone to the civil legal process recently. And so, you know, one of the areas is with regard to the selection of juries and peremptory challenges. And so one thing that's happened in Washington State that no other court has done is that it has operationalized implicit bias. So a way to look at racially disparate outcomes and to figure out a pathway for a remedy. First, they did it with a court rule by saying, well, if an objective observer viewing the circumstances, aware of history, aware of implicit bias, could see a strike and believe that race played an improper role, then that strike is not permitted. Now realize this is not outcome determinative. It just allows you to go back. And so I think that's why it's been allowed to take place. And so then if you have the objective observer standard operate in this context, and it's gone to other states, California has adopted it by legislation, then it provides a standard to address other race-based misconduct, race-based prosecutorial misconduct. And so the state Supreme Court has also gone there. Race-based juror misconduct. And so then when we think about it, we have outcomes that we know are infected by the operation of bias. We don't know in any particular case precisely if it led to this outcome, but if we think about a process-based remedy, what you get to go back, do it over. And it's a way then to try to address the operation of racism outside of the limits of federal anti-discrimination law. And so then what I would hope to do is to start thinking about other states and the projects that we could do with regard to other states. But again, what I think we do, returning to your question, Professor Gersen, is that we do a disservice to our students if we don't talk about these things. And so in some ways, I think in legal academia, we have the majors, right? That's the federal system. And we have the minor leagues, and that's the state system. And I really think that we need to get past that because we do a disservice to our students if we don't. So let me stop there.
This is wonderful. Thank you. So I just wanted to make a couple of observations and then maybe pose another question to all of you. What's so interesting here is that each one of you has detailed things that you teach that are not completely discontinuous with the approach that you may have favored before the Roberts Court. By no means is it like a sudden development that you've been teaching this way, but that involve things like context, whether it's history, method, originalism, for example, whether it's institutions and design and reform of the courts, and thinking about the place of the court in a constitutional democracy, the importance of the larger ecosystem and understanding how the court fits into that larger ecosystem, and the role of state courts and how it interacts with the federal system. All of those things are approaches that kind of can encase and provide context around the central thing that many law professors have thought of themselves as doing, which is like teaching the law of an area, teaching constitutional law, teaching constitutional doctrine, teaching how to make arguments that courts will recognize as valid arguments. And so one thing that's interesting to me is that these are approaches that have not come about suddenly. I know that you've been working toward them for much of your career, but it is in this particular time in 2023, 2022, 2023 and beyond that we're seeing these approaches being actually highlighted more, talked about more, and seen as more essential to the actual teaching, so that our previous approaches that were more common might be seen as incomplete or doing a disservice to our students. So one could have said all of these things before, but what is it about this moment and what is it about the Roberts Court that if we can get to that a little bit more explicitly, what is it about this moment and the Roberts Court that makes it such an opportunity, in fact, to deepen our teaching, to make our teaching actually more profound and accurate to really the system that we're living in, and more useful? Why don't, I'm happy to hear from.
I'm happy to go first. And I mean, for me, I touched on some of this before. I think that you're right that these issues were always there. And for many of us, I'm sure on this panel, we've always thought about things in a contextualized way, but I think recent events gave it more urgency. So, I mean, I think on the court itself, the thinking about the structure of the court and the court itself and the institutional design issues, something about the combination between the confirmation battles and Dobbs raised a new set of questions. And they raised questions about they made people more open to thinking about questions around the legitimacy of the court, which I don't use lightly as a term. I'm just saying that people started to ask questions in that tenor and started to think about questions of people who aren't sort of insiders in this, start to think about, why is our Constitution so hard to amend? Why do we have lifetime tenure for our judiciary? Why are we bound to a methodology? And this is how people describe it, Professor Barnett, and too simplistically, Professor Goodwin, and ignoring the post-war amendments, but why are we bound to a methodology that excludes women, right? And so the questions just became more fundamental. I mean, in a piece that I have with someone that's sort of a post-Dobbs empirical piece, I mean, describe it as questions about democratic legitimacy. Like, why is this a method that is our constitutional method, our constitutional design, are these questions geared towards a modern democracy? Is this sustainable? And so I think there's that. And then I teach interdisciplinary classes. I mean, I taught a class on inclusive democracy, co-taught it with a colleague, and we had political scientists come in, and they really see a whole range of forces as challenges around political polarization, economic inequality, but they do see the court and federalism as really distinct features of the way in which the United States is structured, just the power we give to courts, and also the fragmentation of federalism. So all of those features become things that we're not trying to fix them, but they're just sort of opened up as discussion items in any serious discussion of democracy. When you were listing what I teach, I think now it's like, the thing I teach is democracy, American democracy, right? I think all of us in some ways are thinking about these questions, and we've been forced to enlarge the frame on that. And then I don't know if any of us have said it, but January 6th, I mean, how could that not make you think about questions about how long should our transition period be? What should the design of our electoral college be? As well as fundamentally, why are we so polarized? Why are we driven to the point of political violence? I mean, all of that, I just think that our conversations have to get deeper. And we also have to be really careful about how we talk to each other about things. I think it's, for me, and I'll stop here, but it's also, I inserted things that I never had before in my curriculum about what kind of environment do we want to create in a classroom. And I have my own views on that, and how I want my students to talk to each other. And then I invite them to also participate in the design of those norms, because I think we should model a kind of democratic citizenship and that we want to create.
Professor Barnett? And please, anyone in the audience who would like to submit questions, please do so in the chat.
I think the obvious reason is that there hasn't been one Roberts Court. There have been two Roberts Courts. The first Roberts Court, the earliest Roberts Court, should better be understood as the Kennedy Court. Justice Kennedy was the swing vote. He would sometimes swing towards the conservatives on the court. He would quite frequently, in key cases that people care about, swing towards the progressives on the court. And as a result, you had a real mixed bag that was reflected from, that was a product of the mind of one justice, Justice Anthony Kennedy. And with his resignation and retirement and replacement by multiple justices, we no longer have that court anymore. We have a different court. And so the different court is, as I said, I think it's a 6-person conservative court. It was formerly a 4-4 with 1 swing vote. Now it's a pretty solid 6. That's going to be a different, it's going to be a fundamentally different court. Roberts 2 is fundamentally different than Roberts 1. That is going to cause a lot of shakeup in how you teach the material. And I'm good. I have to do one book plug because I was touting my casebook, but I understand it's unlikely for people who are listening to this webcast to decide, oh, you know, I'm just going to stop using my casebook and use a different casebook. But it's just because of that Professor Josh Blackman and I produced this book, which is now in its 2nd edition, An Introduction to Constitutional Law, 100 now plus Supreme Court cases everyone should know, because this book presents the cases in a narrative way of the sort our casebook does. But it's accessible, it's thin, it's meant for the general public, it's meant for law students. And so you could superimpose the narrative approach to teaching and provide the narrative context with this book, no matter what casebook you're using. And with this casebook, students also get free access to the 75 videos that we've made, and professors can assign those videos without having to assign our casebook, though I wish they would.
Thank you. I'm going to go get it now.
I'll jump in here, and I really appreciate Professor Johnson's comments about January 6th, the status of our democracy, the vulnerability of our democracy, which is something that has, according to the World Economic Forum, has become more vulnerable over time. January 6th certainly is a flashpoint about that. When we think about the cases and recent decisions that have come out of the Roberts Court itself, and I think that there is something to be said about and a pause about, what is a Roberts Court? What does it represent? Does the frame of Roberts Court actually overstate what it is substantively? Is Chief Justice John Roberts actually in control of what is a Roberts Court? And I think that there can be much debate about that. But when you think about where we are as a democracy, and to the extent that our political frame has now turned explicitly and vocally to the judicial frame, with the past president saying that there were only certain types of judges and justices that would be appointed, that casts a shadow on the court itself. And one can't deny that the public has articulated concern about the court, whether the court has become politicized. And then it's not just the Supreme Court, it's the lower courts and also the state courts. When we think about where we are as a democracy and the kinds of questions before us, both at the local level and also the federal level, whether it is voting rights and voter suppression, we've seen changes there in the political landscape and also in the judicial landscape. With regard to questions of reproductive freedom and abortion rights, we've seen changes taking place at the court, and we've seen how that's created a kind of reverberating effect at the state level with a bit of disarray. It was both Justices Kagan and Sotomayor who talked about the weaponization of the First Amendment before the court itself. There's so many different categories that seem to be stable, even in courts where there were ideological differences, as Professor Barnett has spoken about. I mean, that's been pretty consistent that we have ideological differences on the court, but we've seen now the expression of our democracy in its own vulnerability in a way in which perhaps we have not seen in decades. And I think that further adds to the point about being more thoughtful, more nuanced about what we teach, and also making sure that we provide the materials available to students such that they can think in substantive, rigorous ways about what it is that we're trying to express. Sometimes the cases alone can't do that work, and I'll end it there.
Thank you.
I don't have much to add to all of those terrific comments, but I do just want to pick up on where Professor Goodwin left off about sort of our goal of teaching students about things that they're interested in and that they're sort of getting from us implicitly, if not explicitly. I think, the one really sort of simple answer to your question, Professor Gersen, is that students are pushing more, I think, are bringing these issues into classes more, at least that's been true in my experience in my classes that are supposed to be about other things. I taught legislation last spring, and we were talking about a particularly controversial case, and a student raised her hand and said, "Ooh, these judges are just politicians in robes." And I so wanted to say, okay, let's pause and focus on that for the next 2 weeks and, actually unpack what you mean by that and what you don't mean and, learn something about this. And I think that like this sense is in the background, or these issues are in the background of almost everything we teach in law school, which is sort of like, what are the courts doing and why are they doing it? But they're not the focus. And I think it's the more students bring them up, particularly when they're sort of bringing them up in a way that isn't completely thought through, I think the more felt need on the teaching side to actually speak to it. I mean, it's a little bit, the best analogy I can think of, and it's not a great one, is like law and economics being in the background. And if I had students all the time raising their hands and bringing up like cozy and bargaining, I'd want to teach it at some point. And I think that's a little bit what's happening, at least at Duke right now in teaching about the courts.
So if I could return to the theme of democracy that Professor Johnson and Professor Goodwin raised, I'm a broken record. So states, right? So in 2012, my assistant director drafted the Washington Voting Rights Act, modeled on the California Voting Rights Act. It took 6 years to get passed, working with many, many partners, but it's led to changes, including where you have majority Latinx governmental units who had never had a representative, now all of a sudden having Latinx representatives. And so it's again this idea that when we're thinking about law and democracy, and when we're thinking about students and how they can deepen democratic engagement, which then legitimizes like everything, right? It's how we get legitimacy. Well, we can shore up democratic engagement by doing things like State Voting Rights Act. Sure, there are some states where it'll be much harder to pass those, but it's state by state. You protect communities, you enhance democratic engagement, and I think that's how you get to legitimacy at the end of the day.
Great. So we have time for one very quick round. And so I wanted to actually zero in on the idea of what we are teaching in terms of we are preparing still people who are going to appear before courts, at least some of them, and make arguments to courts that can be recognized as legal arguments. And I think as a constitutional law teacher, I have also wondered, like, do we need to add like extensive courses about the methods that are now considered to be dominant among the justices? So obviously originalism is the main one Professor Barnett has emphasized. I mean, that's not an easy thing to teach. It's and certainly not easy when you're abandoning, if you want to abandon the approach that Professor Barnett mentioned, which is like, oh, this method is, it's not a good method. I don't like it. And some conservative justices like it, but it's not very good. I mean, I'm simplifying, but that might be something that people could have gotten away with before. But you're right that this is not really viable at this moment in time, given where the courts are and where the Supreme Court is. So how do we take this into account? I mean, people get PhDs in history, and we know that it's a method that's really difficult. Now here, this is not exactly the same kind of history that history departments are doing. It's a specific kind of legal use of history in a distinctive originalist method or series of methods that are sometimes in tension. And are we at a moment where we need to think hard about think hard about just making this a much bigger part of how we teach our students to be lawyers. And it takes I would think that it would take a lot.
Maybe I should take first stab at this, since I try to do it already. And I do it more now than I used to, because I used to be trying to teach what 2 justices think, and now I'm trying to teach what more justices think, and so I can justify more time. And I don't have surprisingly enough, I don't have a ready, easy answer for you. I'm going to tell you what I do, but it's not something it'll be easy for other people to do. The Georgetown Center for the Constitution, which I direct, has an annual summer seminar for law students from around the country, 58 law students who come to Georgetown for a week-long intensive course on originalism, the theory and practice of originalism. So that's a 5-day intensive, all-day seminar. We do also include critics of originalism amongst our faculty, and also the different variations of originalism, because there are different theories to be had. Now, that's not something that anybody can do. It's not something that I can do in my classroom myself. But what I have been able to do, and this is why it's not easily replicated, is to assign my students to read the video, to watch the videos, 13 of the videos from my seminar on their own, in order to be exposed to this diverse approach to originalism, in which they're happy to do. And I also, in order to provide an incentive for them to do this, included a question on my exam about originalism. And I find that based on the question I ask on my exam, they take in the basics quite effectively. Other people can't do that because they don't have access to the videos that I have access to. But the audios of these lectures are freely available on the Georgetown Center for the Constitution website, which is on the Georgetown Law School website. And it's called the Originalism Seminar Podcast. So you can't do videos of them, but you could do audios of them. And maybe just, start off by taking a listen to them yourself. And I wouldn't necessarily think that everybody is going to want to sign all 13 hours of this, frankly, but there might be 1 or 2 that would be useful. And I'd be happy to work with anybody who wants to integrate this into their classroom in an advanced way, who just need to reach out to me at rbarnett@gmail.com, and myself and Professor Blackman will be happy to talk about how to do this and by making resources available to you. But I have to confess that this is not easy, because I do believe my role is to teach doctrine. I do believe, as a constitutional litigator myself, I want to teach students what I think they need to know to be effective constitutional litigators. This is one of those skills, but it's not a skill that's easily taught in a 1-semester course while you're trying to teach them all of Constitutional Law 1 or Constitutional Law 2, or even worse, a combined course. So it's a challenge. I've been able to do it, and I'd be happy to work with others to try to help them do it as well.
I'm happy to pipe in. I mean, I don't teach the main con law class, so it doesn't follow directly on what Professor Barnett just said, but one thing to think about is, I know that Professor Lemos and I have both taught leg reg or legislation, which is mostly about statutory interpretation, but it provides a way of making students very self-aware around questions of methodology. And I find that my students who take that class are very good at thinking. First of all, they can make textual arguments and purposivist arguments and dynamic arguments, and so you've taught them something, but they read all opinions differently. They see how they are constructed. That all said, I do have to say that I think that it's a pretty thin account of how law gets shaped, to think about the idea of just resurrecting, the better originalism sort of methodology, or the better textualism methodology. I think it's one thing that's important as a skill for constitutional litigators, but it's also important to understand how social movements and political and cultural movements shape law, either in who gets appointed to the court, and also what arguments are seen as resonant or possible. And then a last thing I would say that really, butts against the whole premise, I guess, of this Roberts Court, is just to emphasize how important it is to teach statutes and legislation, not just through the window of judicial decisions, but as legal documents themselves. A lot of our students won't litigate. They will design regulation, they will design statutes, and they will implement them.
Great.
I'll jump in really quickly to say that teaching methods and interpretation and learning how to integrate that into how we teach within the constitutional law framework, which is broad, I think is very helpful. And as well, I couldn't concur even more, but to think beyond this in terms of social movements, the work of the legislative process. And I think about law and society, the work of empiricism as being so important. Integrating those things, I think, can be very hard for law professors, but I do think that it's a worthy course of action for us. And something that comes to mind, and I'll be quick here, is thinking about how we prepare students to do the lawyering that they will do. And not all of that lawyering will mean that their work will come up to the Supreme Court. Most cases do not, but it yet still is important thinking about that pragmatic piece, which can often be left out of how it is that we teach, what it is that we write. But we have to remember the work that they will be doing. And I do think that it matters thinking about how the court is comprised in these times. What are the arguments that may hold some persuasion before this court? And also paying attention to the fact that we might overstate how it's just the Supreme Court, ignoring the kinds of movements that are taking shape at the district court level and also the courts of appeals. And of course, as Professor Schenk has mentioned, what also happens in state courts too.
Well, can
Can I just drop in one? I did put into our internal chat a link to the Originalism podcast for if you can distribute that. I can't send that to the participants as a panelist, but maybe someone else can before we adjourn. I also wanted to stress, so it doesn't sound like special pleading, you can't teach originalism effectively without teaching the competing theories of interpretation as well. So for example, I don't think that Justice Alito's opinion in Dobbs is an originalist opinion, but that means it's incumbent upon me to explain what is it. I think it's a constitutional pluralist opinion of the kind we're actually quite familiar with. But what makes it different is it's a conservative constitutional pluralism as opposed to a progressive constitutional pluralism. So that means I'm going to have to teach pluralism along with originalism in order to even teach originalism and contrast it. And we can just go down the line with common law constitutionalism and all the rest. So I don't want to suggest that what we need to do is teach only originalism, but you can't teach originalism without teaching its rivals.
Well said. Thank you. That is all extremely illuminating. Thank you to all of you. We're really pleased that we were able to have this event with all of you participating. Thank you so much to our panelists. Thank you all for joining us, and have a great afternoon.
Thank you.